All right, conditional offers. Want to just do a fly through this because now I know there are going to be some people who are worried that we'll never finish. There are some people who are worried that we're not going to get through all of the material. There are some people who are just taking it in their stride. Hopefully most of you are in that third category. We're not going to get through all the material. We will finish. Just want to assure you of that. When I say we won't get through all of the material, we're still just going to be high level. There are plenty of interesting questions on topic 5 for you to consider. And of course, the last assignment that you have as an individual is your critical analysis piece. You get to decide which bits of this, in a sense, that you want to focus on as you do that assignment as well. So conditional offers. When we last left this scenario, I think we were pretty much at the stage, we've compared the on-market, off-market process, but we're looking at some conditions that are associated with the evil company's offer, so there will be some conditions. Common conditions. Usually there will be a condition around, if we have conditions at all, that they need to receive acceptances up to a specified minimum percentage, which makes sense. And that's how we end up with equal treatment. So offer to buy everybody and anybody's shares at a particular price, but I'm only actually going to complete and pay for those shares when I get a minimum of usually 50.1%. Or sometimes 90%, because 90% allows for compulsory acquisition. Another common condition is that nothing in the list of things that could go wrong in section 652C 1 or 2 occur. Have a look at those yourself. We spoke a number of times in passing about underwriting and underwriting conditions. Often the underwriting agreements will refer to those provisions as well. Regulatory approvals, we've spoken about them at some length. This lovely open phrase, again often used in underwriting agreements, no material adverse changes in the financial position of the target company. So if after the offer was made, Tingyu and Shushu issued a profit warning, it might be that that was seen as a material adverse change, changes the mathematics or the economics of the transaction, and the evil company might want to withdraw their bid at that stage. Or no issue of securities by the target or its subsidiaries, and no sale of the main undertaking of the target. So again, that's preemptive defence strategies. So if it turns out that Tingyu thinks one of the ways that she can get her $4 a share is find a different bidder, need somebody in the room who hasn't had a commercial transaction, has been part of this transaction before, I'll find you in a minute. But if we have she might be looking for another bidder, she might be looking for an opportunity to sell an asset, she might find other ways to be able to defend this strategy or to get a bidding war happening. And so one of the ways that this might be dealt with up front is that could put the initial bid at risk. Shareholders love it when there are two bidders fighting it out for the best price in the target. Shareholders hate it when companies do things that put the one firm bird in the hand at risk. Conditional offers. Law of contract applies. So if a condition is permitted by the law of contract and not prohibited by statute, you can include it. Pretty straightforward. It only applies to off-market bids. Because a market bid offers are accepted on market, you can't actually have conditions. You know, it's actually, they're just transacted on the market. Again, should be pretty straightforward. Talked about common conditions already, obviously duplicating up for some reason. Oh!
That was quick. You are flying through the time.
That was crazy weird. I was not touching any, oh, maybe I did touch the secret button. Shushu, you had a question while I go and find my slide. Oh, okay. I might have moved the order of the slides around a little bit. I know, I felt so good and virtuous that I had all my preparation done in advance. And then, in a surprise move, I looked at them all again in order to prepare for today and thought, yeah, actually I'm going to move that around. So, in fact, having said that, actually when that went through really quickly, these slides here are just the slides that are before this one here, which you can't see clearly, are really just talking about the different kinds of conditions. I think in the conversation that we've had so far, we've spoken about them enough. If anybody has a specific question, we're happy to deal with it. But the slides will give you some guidance to the section numbers that I have been artfully avoiding in the conversation, because I think it's a good idea not to remember too many section numbers because it forces you to go and look at the law every time and see if it's changed. But that could be me justifying my inability to carry numbers in my head. Sorry, go back to that. Prohibited condition. Oh, Catherine, sorry. Just work out where I am. Yeah, they've moved around a bit. Don't worry. Don't worry. What I've done is I was going to talk about prohibited conditions before I talked about actual conditions, and I moved those sections around and I changed some slides a bit. Caught out. I'm sorry. This is why I don't like giving you the slides in advance. For those of you who are listening on the recording, by the time you get this, I should have put the correct slides up. Okay, so there are some conditions that are prohibited conditions. So the law provides that there are certain things that you cannot include as a condition. So, for example, a maximum acceptance provision. For example, that an offer will terminate or maximum consideration will be reduced if something happens. So, at any given time, the offer that's in the market needs to be the best offer that's in the market. You can improve the terms along the way, but you can't reduce them. You can't be selective about who the vendors are. Okay, under a takeover bid, you could do a selective arrangement, as in enter into an arrangement to just buy the Tinyu Shushu parcel, as we've been calling them, if the non-involved shareholders agreed. But under a takeover procedure, the offers need to be available to all vendors, to all target shareholders. You can't require the consent to benefits. So you can't include as a condition that certain individuals are going to benefit or get extra things. Everybody has to participate equally. So we'll talk about them in a little bit more detail as we go through. So at any given point, the offer can go unconditional. So you can remove the conditions, you can waive them or state that they're satisfied at any point. And essentially say, in 7 days' time, we're going to complete on all of the acceptances that we have at that time. So no changes can be made in the last week of the timetable, and the bidder is the one who goes firm on when that last week occurs. So, and that's essentially by going unconditional. And you do that, surprise, surprise, by giving a notice to ASX and ASIC, or only ASIC if you're not a listed company or the target's not listed, and basically saying, we're going unconditional now. So, prohibited conditions. What are they? An off-market bid must not contain any conditions that have the effect of doing any of the following. Maximum acceptance condition. So the section there is 6261. A condition that doesn't permit the bidder to acquire securities from all acceptors, so selective vendors, feel like this is a bit repetitive here, requires consent to benefits for an officer of the target. So, so if there's any kind of special treatment, anything that would require the approval of members for something that Shushu or Ting Yu are going to get in this deal, improved salary or something like that, or relates to the bidder's opinion event within the bidder's control. So a condition, and in fact actually I probably suggested a prohibited condition earlier on today in relation to the arrangement with Ben. Because I think actually thinking about it out loud, I suggested that maybe the condition was an arrangement acceptable to the bidder about the contractual arrangements that Ben had. Mea culpa. You would need to actually define a minimum or a maximum or something to have it as an arbitrary statement, need to enter into terms that you're randomly acceptable with, or it might be the results of, say that we have a valuation report comes in. Unfortunately, your existing businesses are easier to get examples out of, but maybe there is some piece of artwork that is in the gallery and subject to you being happy with the valuation of that art would be a prohibited condition.
In our circumstance, though, like from Tim's perspective, his interest is in minimising the liability of that poison pill, which is, you know, my character's ability to exit. You're saying there has to be a high level of specificity around what his...
Yeah, it's... I mean, that particular contract is kind of bizarre in, like I can't actually imagine how that wouldn't be priced in originally anyway, because you've already got on market, I mean that would have been declared, but you just picked a number, $46 million. But yeah, there's, and this is actually why the poison pill provisions have become substantially fixed, because what the law is trying to achieve is an open and consistent market that provides efficiency and a competitive environment for listed entities. So, and all competition law protects competition, it doesn't protect the competitors themselves. So it's providing for a competitive environment. So in the kind of scenario that you're talking about, what's more likely to happen is that either pre-announcement, depending on sensitivities and alignment and the extent to which you had existing relationships with the target or the company with that rogue contract did, what's most likely is that you would have some conversations before you even made the announcement, but otherwise pretty much straight away, because everybody wants to de-risk, right? Everybody wants to remove risk. So you want to have some sort of commercial situation. So any issues that arise in the public-facing due diligence, usually bidders will be trying to deal with that. And in fact, given the kind of resources that they had, if I had your kind of resources, Tim, in the scenario that we're talking about, before, without even mentioning your hopes and dreams in relation to the art gallery business, you might approach Ben completely separately in your capacity as the chair or ultimate owner of the Pineapple Art Gallery and see if you could buy out his rights under that contract.
And he could
That would be...
settle that for lesser amount as well.
Yeah, it's called factoring. It's like you got $47 million in the future. You might be prepared to sell that for 25 now or something. So, you know, there's, again, these are contract issues at the end of the day. They're commercial things. And
So that's not a competition issue? If I contact him directly?
if you disclose, or if it could reasonably arise out of that conversation, that you are intending to participate in a market-sensitive transaction, and it's not completely confidential, and it remains, or it's sufficiently certain, Listing Rule 3.1 might require you to make some sort of disclosure. a $2 billion company spending $25 million on buying out a contract that has some relevance to a subsidiary, provided that you really lock down that this is part of a larger strategy that's building down. If it couldn't be seen that way in the press, if you had the right kind of confidentiality, I don't... Again, we're making this scenario up, so... It feels very real, I know. You're all going to be looking for investments in... What's our market code for this? TAA. Tingyu's Awesome Art Gallery. You'll be all wanting to make investments now. But that could be an insider trading issue. But again, I guess my point here is takeover is process. Takeover is the noun to the verb of the transaction. The transaction is commercial entities trying to achieve growth, achieve profit, achieve a commercial advantage of some sort. And so it's really around, well, what's the appropriate process to use, and how do you make sure that you stay within the confines of what the law allows. And at the end of the day, from a contract law perspective, unless there's a provision in a law somewhere that says you're not allowed to do something, from a contract point of view, you just need agreement, consideration, intention and capacity, and and you're there. You just go through those processes. It doesn't have to be a good deal, or whatever. So as long as you're prepared to pay tax, well, actually, which we've established that you're not, but you know, as long as you're prepared to spend money making sure that you don't pay tax in a legal way, we're fine. Bidders can only purchase securities on market in excess of the 20% threshold when the offer's unconditional. Okay, so if you've got an off-market takeover that's subject to conditions, from the point that that is announced, it is an offence to buy more shares. It's also an offence for your associated entities to buy more shares at that point. But the minute you say it's unconditional, in addition to the shares that the acceptances that you might have that can be completed at that stage, you can buy on market as well. All right, this is a slightly complex area, or more complex than some of the others, is the collateral benefits rule. So the bidder and the bidder's associates are prohibited from giving or offering to give or agreeing to give. In other words, doesn't matter whether it's a legally binding contractual arrangement or an understanding or a nod or a wink or an invitation to treat. Basically, you can't give a benefit to a person who's involved in the transaction unless those two conditions are satisfied. So the prohibition operates during the bid period and so during the bid period you need to, you can't give a benefit that's likely to induce a person who receives it or an associate of that person to accept an offer or to dispose of securities, or if the benefit is not offered to all holders of securities in a bid class. So let me give you an example. If, let's say an airline is seeking to acquire all of the shares in another airline. If it were to say the first 100 shareholders who accept this bid will get 1 million frequent flyer points in our shareholding program. So it's a script for share offer. Let's make it up. It's Qantas is acquiring Virgin Atlantic, and it basically says the first 100 shareholders who come in we're going to give them 1 million frequent flyer points, Qantas frequent flyer points. So that's clearly designed to induce shareholders who happen to also be frequent flyer members, or even maybe if they're not, it's probably worth them signing up to enter the transaction. Would that be a collateral benefit? Yes. Why is it a collateral benefit? It's inducing people to enter into the transaction. Is it a prohibited collateral benefit? Yes. Why? Don't worry about the number, I probably won't remember either. The reason it's a prohibited benefit is because it's not offered to everybody. It's only offered to the first 100. Okay. So that's the kind of issue. Now, sometimes they can be other. So what was that, Molly? 627. Thank you. So what if the offer was to use employees who are shareholders? All shareholders who are employees who accept the bid will be guaranteed that their jobs will continue. No. Because it's not available to all, because not all shareholders are employees. And it's not an offer of everybody who accepts will get a job. All right. ASIC has a power to grant an exemption from or modify. And these happen from time to time in relation to very specific transaction relevant things. So again, I think the reason frequent flyer points came to my mind is that there have been in sort of frequent flyer or loyalty programs where one of the benefits that has been offered is if there is a merger that a member, well, it'll say that people who are members of either program will have their membership merged, and that actually will apply to, in the circumstances that I remember, I can't remember the case now, but it would apply to all members of those loyalty programs, but on the off chance that it could be seen as a collateral benefit because not all shareholders are members of those programs, modification would have been granted.